Hello, my name is Costa Avgoustinos. I'm an academic at UTS teaching administrative law and constitutional law, and I'm the author of a textbook called Autonomy's Administrative Law, which is available at your uni bookshop. Very basically, the difference between public law and private law is public law involves the government and private law does not, okay? You can kind of think of it in terms of public law as public sphere, private law as private sphere, okay? So public law basically entails constitutional law, administrative law, and criminal law. And the thread of consistency between all of them is that, the government is, is like sort of front and center in the issue. So with constitutional law, it's in terms of like what can government do and government bodies, executive branch, legislative branch, etc. What can they do, to stay faithful to the Constitution? Administrative law is if you want to challenge a government decision. So it could be a local council decision, it could be a government department, it could be, much higher, it could be a cabinet decision, okay? Criminal law is basically when the government's taking you to court, when it's the state is trying to punish you for some kind of criminal misdeed for the good of society, okay? And so private law, on the flip side, is more disputes arising in the private sphere. So it could be just contractual disputes, it could be corporations and law involving corporations, which are non-government bodies, so private sector bodies. Very good question. So freedom of information legislation started coming into place in the 80s. And it was all about, making government more open and transparent. You can get access to all these documents that relate to you, et cetera, et cetera. And it didn't really live up to that promise, okay? So in the last 5 or so years, there's been acknowledgement of this and there have been changes to FOI legislation to make it more effective, to give people better success when they apply and put in an FOI application. But there are still a lot of critics that say the changes they made, aren't nearly enough to combat the problem. A big problem, if you're talking about marginal groups and people from low socioeconomic background, a big problem is actually that an FOI application can be very expensive. What they do is that if you put in an application, they'll charge you per hour it takes them to find the documents you're after, and then they'll also charge you per hour in making the decision on whether to give you those documents or not. And so what happens with that is that a lot of people say that it's been very random how much they charge you, okay? And there's no real way of, checking on it. And there's been lots of criticism that some government bodies are using it as a deterrent, making it really expensive so you don't ask for access to your documents. So there have been a lot of problems like that, and they've done a bit of changes with that to try and make it cheaper, but there's still lots of ways that it can really rack it up in terms of price. So with FOI legislation, it's expensive, and also it's really hard to try and check on them whether whether they're legitimately knocking you back or not. This question breaks my heart. What I'd say to this is, first off, what is administrative law? Administrative law is when you want to challenge a government decision, and what can you do about it? What can the courts do in terms of judicially reviewing it, et cetera, et cetera. Difficult and boring. First off, I would agree with you that it's difficult. I think it is very difficult. Part of the reason why is because I think that as an area of law, it's actually quite messy. I think a lot of areas of law actually work nicely with common sense. Like, I think that torts make sense. I think that contract law, makes a nice kind of sense. You understand why the law is the way that it is. With administrative law, a lot of the reasons why it is the way that it is because of stupid historical technicalities that, still exist. There's lots of really stupid, antiquated things that still exist in terms of how the writs work, in terms of how standing works, etc., etc. There was a bit of acknowledgement of that when the ADJR Act came along, because the ADJR Act The Commonwealth passed that in the 70s to try and simplify the common law and a few of the like messy things that have existed in it, but in my opinion, didn't go far enough. So when you say it's difficult, my heart goes out to you. I agree that lots of times if you're having trouble understanding it, it's not you, it's the law. In terms of it being boring, I think it's difficult because, it's boring because it is difficult. Like if it's hard to understand, it's hard to get into it. But I actually think that as a subject, it can actually be really interesting because it's basically about keeping government honest, okay? And it's about, dealing with government, abusing their power. And you have really interesting cases that are involved in it. You have lots of refugee cases, which are life and death kind of cases. You have things like, David Hicks, trying to argue that the Australian government has some obligation to him when he was in Guantanamo Bay. He had to do it through administrative law. So there are interesting cases in there to, keep you fascinated, but you have to sort of understand it first before you can enjoy them. The three, toughest areas that I grapple with, I think I'm going to sort of tie them all together. They all relate with jurisdictional error, which I think is the big hurdle to get with when you're studying administrative law. So the tough thing with jurisdictional error is trying to understand that it works as a ground of review, just like all the other grounds of review, but it's also at the same time, it's kind of an umbrella term, okay? It started off just as a ground of review, and then judges got a bit creative with it, and they expanded on its meaning. So now any error of law you can class in certain circumstances as either a non-jurisdictional error or a jurisdictional error, okay? And so what that means is that sometimes other grounds of review could count as a jurisdictional error. So in the case of Plaintiff S157, it was a refugee case, and the applicant was claiming that they didn't get natural justice. And the court was open to the idea, which is normally natural justice could just be any error of law, non-jurisdictional. But if it's in a refugee case, natural justice is so crucial, do you mean, it's such an important kind of matter, life and death kind of matter, that if you stuff up natural justice in that kind of area, then that counts as not just any error of law, but a jurisdictional error. That suggests you don't understand your jurisdiction. Okay? So in that way, they said, these regular grounds of review could count as jurisdictional error, depending on the circumstances. So same thing with, took into account a relevant consideration or acted for an improper purpose. Sometimes they could count as a non-jurisdictional error, and sometimes they'll count as a jurisdictional error. Now, so the question was asking for three things. The other two things I'd say tie to that, which is privative clauses and remedies. And the thing is that you might be wondering, why does it matter how I class an error of law? Whether it's jurisdictional, whether it's not, who cares? They still did something unlawful, etc. Lots of times it doesn't make a difference. Lots of times, as long as it's an error of law, that's enough. But there are two incidences when you'll try and argue that you're trying to push that it's a jurisdictional error. That's number one, if there's a privative clause, and number two, if you're after certain remedies. So with a privative clause, what the courts have said is at the Commonwealth level, or at the state level, at the High Court or at the Supreme Court, the only way to get around a privative clause, besides the Hickman principle, is to argue a jurisdictional error. Okay? They say a privative clause will stop the court, examining an error of law, but it can't stop them examining a jurisdictional error of law. So what does that mean? It means that all lawyers, if they're trying to get around a privative clause, they're going to try and push that the error of law they're arguing counts as a jurisdictional error. Very, very briefly, a jurisdictional error just means that it's a more serious kind of error. It's more complicated than that, but that's it in a nutshell. So with a privative clause, you're going to have to try and argue it's a jurisdictional error to get your case heard. And then the other one, why jurisdictional error could be important, is with remedies. So if at common law, you're wanting to get a writ of certiorari or prohibition, those two are limited by the grounds of review you can argue. So with certiorari, you can only argue jurisdictional error, natural justice, fraud, and error of law on the face of the record. Okay? If you can't get those bottom three, you're going to try and have to argue that it's a jurisdictional error. With prohibition, it's even more of a limited list. The only time you can get prohibition at the common law level is if it's a jurisdictional error or it's a breach of natural justice. Okay? So if you're not dealing with a breach of natural justice, then you're going to try and push really, really hard that it's a jurisdictional error to get that writ. the 3 errors I see, well, number one is this idea of jurisdictional error. So we already talked about that. That's a big problem. That, getting that right can be very impressive to a marker, but also can be a big stumbling block. The second one isn't specific to administrative law, but it's really important, which is you have to answer the question. Yeah, as a marker, the big thing that gets into it is you can't you don't answer the question that you want to answer. You answer the question that we give you. Okay, and I think because administrative law is quite difficult, people really veer off on a tangent. I know it's a really stupid thing to say, but the reason it's important because students do this quite a lot. And with any assessment you've got, if you're doing an exam, there's going to be a limit on time. If you're doing an essay, you've got a limit on word count. Okay, so if you're wasting your time or you're wasting your words on something that you don't need to talk about, as a marker, I think that, you're wasting my time, okay? And you're not getting all the marks that you could have, yeah? And it also sort of suggests that you don't understand, exactly what's going on if you can't sift out the important stuff from the unimportant stuff. So really important is to answer the question. My tip on how to do that is, whether it's an essay or whether it's an assignment, always use the wording of the question, okay? Use the wording of the question again and again, because it'll flag to a stupid marker that you're answering the question, and it also makes quite clear to you. If you're constantly thinking in terms of the words of the question, it's keeping you on track, okay? Making sure that you don't let yourself get off on a tangent. Yeah, so that's, second bit of advice. The third error that I see is really important in administrative law, and this kind of separates the good students from the great students, is if you recognize in administrative law, very often what the court is doing is a balancing act. They're sort of balancing, the ideal for how they want government to act and the practical realities. Okay? So they've got the ideal, they've got, you can't be biased, you can't, take into account, you can't, apply policy inflexibly, la la la. But what you'll see in these cases is that there's a lot of exceptions where courts do try and be wary of, the realistic pressures that are on government, okay? So, for example, with the no bias rule, they have this idea of you can't have a decision maker that's biased, but they will acknowledge that, if it's a minister, they have to talk to the public and be quite open and vocal, because they're an elected official. So if they say anything that's a little bit biased, then, it's okay, yeah? Another thing is inflexible policy, yeah? It's you have to look at the material, facts and the individual merits of each case, etc., and you shouldn't apply policy too blindly. But the courts have made a lot of exceptions to that in terms of, but there are some government bodies where that's unfeasible, yeah? Sometimes it's okay, if it's just a panel of 4 people, it's not some department with great resources, it's okay if they're just sort of, being a bit too strict with the policy and they can't give every case, its individual attention that, maybe a court thinks it deserves. So always trying to do that balancing act right between being ideal and being practical to government realities, is really important in administrative law.